Good morning, everyone. Scott Butler here at OGRA. Thank you for registering and signing up this morning. We're about to start here momentarily. We're happy to have Charles Painter and Murray Davison from PM Law, Paterson, MacDougall, LLP, joining us today to answer your questions. As you know, the province will be undertaking a review of joint and several liability more holistically, and this is an opportunity for you as municipalities to provide input into that process, but we understood there'd be a lot of questions relative to this process, and a lot of questions that you'd be looking to have experts provide you with some clarification for, and we're delighted that Charles and Murray have agreed to do this today. In terms of process, you will see on the right of your screen a chat box. Recognizing that we have 100 people, 100 different connections on this call, it would be a little unwieldy to try to do it as a conference call. We'd ask you, if you have any questions at any point, to type them into that dialog box on the right side of the screen, and I will, as the moderator, put those questions up to Charles and to Murray, and they will answer them there. So, without any further ado, what I'm going to do is I'm going to turn it over to Charles Painter, who's going to run through a slide deck. You should be able to see that on your machines. Charles?
Thanks, Scott. Good morning and welcome everyone to this webinar. Very grateful to be here at Ontario Good Roads offices here in Oakville. Once again, they're stepping up and taking a leadership role in the latest review of joint and several liability. With me here is my good friend and legal partner, Murray Davison, and together we're going to run through a slideshow that I presented a few months ago at a conference to refresh everyone's memory briefly about what the heck is joint and several liability from a conceptual standpoint, and then to go over and review the options for tort reform that were up on the table the last go around and that are being currently discussed, and give us, a basis then to have a further discussion. One thing I've added to the presentation today is I want to review the list of questions that the Ontario government has sent to all leaders of council across the province. Those questions and the answers that you're going to be providing to the government are going to be critical to determining what's going to happen, if anything's going to happen, in this latest review of joint and several liability in the province. And there's some key sort of takeaways that I think we can share in our thoughts on what those questions tell us about the mindset of the government. So, gonna run through my slideshow here. Let me just get to the slide deck. So this is joint and several liability in a nutshell. Everyone's pointing the finger at one another, trying to get someone else to pay. So this is a diagram of joint and several. All kidding aside, the concept of joint and several is extremely important to remember and understand, because this is what the lawyers at the Attorney General are thinking about, and so it's important to be very clear. So from a conceptual standpoint, joint and several liability is based on a principle of law called in solidium, meaning where you've got two or more what are called tortfeasors, two or more parties that cause damage to a plaintiff, then the idea is that those damages are the indivisible result of their wrongful actions. And it rests on the principle that where a person is at fault with others for this indivisible common damage that this victim has suffered, then each person at fault should be liable for the entire loss. The old in for a penny, in for a pound concept. So this in solidium doctrine is extremely important to understand because it differentiates several damages that are different in nature, caused by the same wrongdoers, versus the same kind of damage. So joint tortfeasors under common law before statute was made was where one of them was the principal or vicariously liable for the other, so an employer-employee type situation, where duty imposed jointly on them was not performed, so all of the wrongdoers had a duty and they all breached that duty somehow, and or where there was a concerted effort between them towards a common end. So 3 guys are robbing a bank together, or 3 people are robbing a bank together, and they go in and hurt somebody or do something. That's their common goal. So those are joint tortfeasors. And at common law, they couldn't be considered joint unless they had combined together for some common purpose. So by extension, then, the logical opposite to that is where you have tortfeasors, wrongdoers, who are not acting jointly, then they are necessarily several, meaning they're separate or independent. And there's actually 2 different types of those kinds of wrongdoers in our legal system. There are those whose acts combine to produce the same damage. So they're not acting in concert, they're doing totally separate things, and they still produce the same damage to a victim. Then you have several tortfeasors whose acts cause entirely different damages. And so the first example is a several tortfeasor who's liable under the solidium doctrine because they produce the same damage together with someone else. And a classic example of a several tortfeasor is being held 100% liable for a plaintiff's indivisible loss is a road authority, right? Who's not acting jointly. Let's say you've got a driver in a winter road and they've got a passenger, all right? That driver is held liable because they're speeding or they fall asleep or they do something wrong and that causes the car to lose control because they're driving. But it's the surface of the road also gets blamed if there's snow or ice. And so that road authority is not acting jointly with the driver. They're concurrent, though. There's a combination alleged of negligence that causes the same victim's loss, right? The passenger gets hurt. So legislation comes along, and historically then, and this is a little history of how we get to where we are today to talk about further legislative reform. But when negligence acts and contributory negligence acts across the country were first passed, their primary purpose, if you go back and read the textbooks or the old articles online, was they wanted to have plaintiffs bear partial responsibility, the idea of contributory negligence. That's mainly why the negligence acts were passed. It wasn't to create joint and several liability. That was around before the statutes. But before statute, contrib was not necessarily going to happen. And so now under the Negligence Act, whenever there's a trial, a judge has to apportion the fault amongst all parties to the lawsuit. And in fact, this slide is a little misleading. If there's a person who should have been sued, but who isn't present in the court, the judge can still apportion damages or liability against them. Of course, you can't collect if you haven't sued them, but a judge can say, theoretically, oh, the plaintiff ought to have sued so-and-so, they're not here, and they're 75% at fault at the end of the day, and it's just their bad luck. But that's the idea behind the legislation. And an extension was this. When contributory negligence acts were passed, or negligence acts were passed, the legislation allowed for the first time for co-defendants to seek contribution and indemnity from one another. And that's not a common law right that existed before the legislation when you go back and look at your history. The contribution and indemnity claims that arise now under our Negligence Act in Ontario are a creature of statute. And so it was thought that that's going to help make things fairer, that while a plaintiff can go and collect 100% of their damages from whoever is found liable, even 1%, that defendant who's got the deep pocket can try and go and collect what they've paid in excess of their fair share from the other wrongdoer. So that is a common law principle, the ability of a plaintiff to get all of their damages in any particular claim or case from any joint or concurrent defendant tortfeasor to whom the court assigns fault. Common law right, based on the insolidium principle, pre-existed our negligence statutes. And so, as I said, the ability of a defendant to seek and collect some of that money back from one of their co-defendants only arose under statute here in Ontario and in the other provinces. So, big picture, what are we talking about when we're talking about joint and several liability? Well, the law of negligence, or tort system, is really both a social, but it's really a big economic institution. The idea is that people who are harmed have to get compensated. And the idea is that they should be put back into the position they were but for someone's wrongdoing. And underpinning that entire system, the principle is that an innocent plaintiff should not go without. And so the innocent plaintiff concept underpins our negligence system and our tort law, as does the fundamental principle that tort damages are intended to only put them back into the position they were but for the accident. Now, in the event that a defendant who's found partly to blame can't pay their share as a portion, whatever percentage that the judge assigns to them, then you have a big problem, right? And the problem has always been, is it fairer for other defendants involved who've got a lot of money to have to pay the shortfall, or is it fairer or better from a social standpoint for this innocent plaintiff to be unable to collect their entire damages? In other words, you know, it conflicts legally and conceptually with the idea that you've got to make the plaintiff whole, right? That they're left without. And so that question is what the government, in my view, from a starting point, really wrestles with. And so the Ontario legislature and pretty much every other province in Canada has consistently answered that question in favor of an innocent, in air quotes, plaintiff, right? And they admit it's not fair. It's the lesser of all evils up until now. And so why? Well, because it's considered more socially acceptable, because it is seen as the lesser of two evils, because it places the burden on non-innocent parties, parties who, to whatever extent, were found to be at fault for someone else's harm and loss. And frankly, it's not politically popular to attempt to do otherwise, right? Especially where the burdens will fall on the more obvious modes of taxpayer-funded systems like OHIP or welfare, right? So here's an email that Murray drafted and I believe sent out 2012, so 7 years ago, back when I was an articling student. No, not quite, but, and you'll see, he had met with Mr. Gregory, General Legal Counsel at the Ministry of the Attorney General, and his associate. And as Murray says, the government appears to have the view that the 1% rule, joint and several rule, is the best way to spread the risk around and ensure innocent victims are looked after. Make no mistake, though, plaintiffs could end up without compensation. The thought of that is not something that anyone seems willing to discuss. And Murray mentions the Supreme Court of Canada case called Ingalls that says that the purpose of the regime which imposes joint and several liability on multiple defendants is to ensure that plaintiffs receive actual compensation for their loss. And again, that's what I was just describing, the legal concepts, and it's really the center of this issue. And apparently, back at that time, Murray noted that there had been several international law reform commissions that had endorsed joint and several liability as the best method for distributing the loss around. So there have been studies around the world that have said, yeah, it's unfair, it's horribly unfair to some, but it's the best we can do in order to ensure that these victims are not, as Murray described, left in the lurch, so to speak. So at that time, the sense was that the government simply doesn't have an alternative yet, which is politically acceptable, so we remain stuck in our present system. Well, here we sit 7 years later, and nothing's changed. So in a nutshell, as Murray mentioned at that time, the government had no appetite to do entirely away with joint and several, the 1% rule, but might consider a compromise, like making an exception for claims against municipalities in certain types of lawsuits, like highway maintenance. And that was a proposal that we had been discussing at that time. However, Murray points that there would likely have to be some kind of a compromise or crisis which leads to even that type of reform. Let me go back. So Murray pointed out that Mr. Gregory contact our friends in the municipal world and encourage you to provide your thoughts to him back then, and the impact that it has on your bottom line. Because they understand the problem, but they didn't have the data to back it up. So 7 years ago, it's the same problem we face today. As the government is coming to you, and I'm going to take you through the data that they're looking for, to justify some kind of change to the system. Because if there's no data, there's no proof that the problem really exists, they're not going to see it as a problem that needs to be dealt with or solved. So people talk about it, but they're saying, show me the money, show me the facts. So, as Murray pointed out, the government of the day back in 2012 was saying that, you know, the ability to insure against these claims and spread the risk is something that they themselves, the government, kept pointing to. You can buy insurance, and that's how you deal with your exposure to joint and several, and this is the way of the world, and so stop complaining. As Murray pointed out, evidence which suggests that the ability to do that, the ability to reasonably go out and insure against the risks, would go a long way and be helpful to supporting any kind of tort reform. And of course, as Murray said, if you have that data, it would be helpful to give it to them as, quote, in spades, right? Because that backs up the argument to a certain extent, although it's a complex issue that you can't just point to insurance premiums as the telltale sign. There's a lot to it. In any event, the government of the day, and we were suggesting then that if you could show numbers that you've had to pay out, and that those larger and larger sums, if they've gone up over the years, increase and have an effect on your premiums because of your claims paid out due to the 1% rule. And surely, you know, many, if not all, of the people listening in on this phone call, those who work in the insurance and risk management departments at their respective municipalities, you know from your experience that there are claims that you're paying, you're settling, either within or your deductible, or even with the insurer's help, not because you think you did anything necessarily that wrong, but because you're exposed to a big amount of damages, and it's better to pay, you know, say $300,000 than $20 million. It's just that simple. You're scared, and rightly so, and it's because of 1%. So Murray mentioned, and I'll close with this comment of his note. He says the AMO survey from last year, so in 2011, I assume, was only moderately helpful then to help the cause, because it only showed that property insurance rates had increased 16% over the 2007 to 2011 period, while liability insurance increased 21% over that same period, and it's only a 5% difference when you compare the increase from property to liability. And, you know, it didn't impress them that much, but again, it was something that one could point to. So here we are, January 2019, and Steve Clark sends out the letter announcing that Doug Ford and MMAH and the Attorney General were going to launch a consultation. They claim that they'd listened to their municipal partners across the province and heard about concerns about insurance costs and liability chill affecting the delivery of everyday public services. If there's an example that you can provide in this data gathering, that there are things that your municipality would offer or could more readily offer to the public, tobogganing hills, maybe a funky, you know, mountain bike course with teeter-totters that you had to close down, that you'd like to have open. Those kind of examples, not a money example, but a practical example of how life in your city or municipality is being affected, mainly because you're trying to avoid getting sued. Those are helpful. So as the government said, we want to gather the facts. They're going to consult with you to develop solutions that make sense. And of course, you'll see the buzzwords here, and ensure that vulnerable, injured Ontarians are compensated fairly. So once again, the innocent victims are not being forgotten. They're going to be right at the center of the discussion for any sort of reform of the 1% rule. And the decisions, as the government noted, must be based on hard facts and evidence. So this is going to be driven by what you're able to provide. And if the evidence and the facts cannot be delivered to the government, I strongly suspect nothing's going to happen. So With that, then, what were the alternatives? And this is something that we hope to engage you today and want to answer your questions and throw some thoughts around, if that's what the participants would like to do today, about possible alternatives. Well, number one is get rid of joint and several, and that's the several liability. Just do strictly several liability, where defendants only pay their individual share assessed at trial. And if there's a shortfall, too bad. So if one of the defendants who's nicked doesn't have enough money or insurance, then the plaintiff can't collect that shortfall from anybody. And I've put on my slideshow that I think it's unlikely to happen because it's considered terribly unfair around the world in any sort of civilized system of negligence law, that innocent plaintiffs ought not to be penalized. So number two, we have the Saskatchewan model. Now, this was discussed the last go-around. So the Saskatchewan model is important because there seems to be some traction, especially with what AMO had recommended the previous review, which was a combination of this model with another model. The Saskatchewan model, just to refresh everyone's memory, is you have a plaintiff who's held partly responsible. So there's a trial, a split on liability. Plaintiff themselves is contributory negligent. So they get a judgment. And then one of the defendants against, say, multiple defendants, one of them cannot pay their fair share. So then the shortfall under the Saskatchewan model gets split amongst all of the defendants in proportion to their degree of fault, and the plaintiff themselves loses a percentage. So if the plaintiff's held 25% liable and there's a shortfall amongst the other defendants of that 75% getting paid, they lose an additional 25% from that remainder. It's a pro rata approach. And that's considered somewhat fair because you don't have an innocent plaintiff in that type of case. The plaintiff did something themselves, so they share the pain. But of course, the deep pocket defendant in this case still gets stuck. They just get a tiny bit of relief. And as I note here, innocent passenger claims are not caught. So if you've got the front seat passenger in some car and they crash, like the Deering case that's quite famous, there's a few others, this wouldn't apply. So that plaintiff would still get everything from whoever they can get it from, even if that person's only 1% at fault. So then there's another model, another alternative that's been discussed, a multiplier model, where a defendant only has to pay a maximum of double of whatever percentage their share is of the liability pie as found by the judge at trial. Of course, in a municipal deep pocket situation, all the judge has to do is make sure they don't get you for anything less than 50%, so that nobody goes hungry, nobody goes short, and they're going to double you up, and 2 times 50 is 100. So call us a little jaded on the legal side, but we see it every day. And in fact, I had a pretrial where a judge just looked us in the eye and said, you know what? You think this plaintiff, any trial judge in Ontario is going to let them go without something? If there's a way to do it, we're going to find a way to do it. And it was a strong arm tactic to try and get us to settle the claim, but it tells you exactly what judges do. They're part of this social and economic system, right? It's a legal system, but it's an institution based on trying to spread around compensation for victims of injury, and judges play a key role in it. And they do often reverse engineer their judgments to come up with the result that they'd like to see. And that usually means our client, if they have lots of money, and most of them do, as municipal governments, pay. So we've got the multiplier model. Now, if my memory is correct, and I'm quite sure it is, last time we went through this reform, AMO championed and suggested all municipalities back a combined model, this combined Saskatchewan multiplier model. And so you start, in any case, with the Saskatchewan model, and then, depending on the size of the shortfall and the split, apply as a cap to that shortfall the multiplier model, so that a municipality will still, at the end of the day, pay no more than double its original assessed percentage of liability. So this is really good in theory, but it only works again if the plaintiff is partly to fault, right? Partly to blame. And apologize, I'm going to keep my finger on the computer to keep the screen going. And this was supported strongly by AMO. And as I pointed out then, and I'll say again, if this was passed into law, it would not solve many problems, but it's a heck of a lot better than nothing. And it's certainly a first step, in my opinion, towards further reform down the road. Because if in theory this was passed into law in Ontario, even just the Saskatchewan approach was adopted here. Forget the multiplier model, you just go pure Saskatchewan. There will be cases caught by it, there will be savings realized, and the world I don't think is going to come to an end. And if we can get something like this, if this is all the government's willing to entertain, then you get another try 5 more years from now, right? And it's been 7 years since Murray wrote his letter in 2012, and we're still under the old system. 7 years under a Saskatchewan model, I imagine some of our clients would have benefited some more than others, depending on the nature of the claims. But as I said, in my view, if it's an all or nothing approach taken in this current review, you could end up losing, and then you're back to where you have been since I started practicing law 20 years ago. Now, at the conference that I spoke at in May, I had an idea to throw out, and this is just an idea, which is a further alternative, something that some haven't discussed, which is leave it alone. Don't touch joint and several liability, but place a clearly defined monetary cap on municipal payouts in certain types of joint and several situations. So say you have a personal injury claim, or say you just restrict it to motor vehicle claims involving highway non-repair allegations. Set a maximum dollar amount which a municipality can be ordered to pay in any case involving multiple defendants. So in other words, limit their joint and several exposure and come up with a number. I put 5 million down. That may not be enough. Some catastrophic cases, depending on the age of the victim, it could be as high as 15 or 20 that has to get paid out into a trust fund. But whatever that number is, set a cap. The few insurance underwriters that I've spoken to about this idea seem to like it a lot, because then they can do their mystical calculations on their spreadsheets, and they know, okay, well, we know how many claims typically come in a year or a 5-year run. We know what the limits of insurance need to be now. We can set our premiums, and we know what to expect. It's all about certainty and being able to predict their losses so that they make a profit. This is something that I would encourage people to think about. And of course, what I haven't thrown up on the slide, but I remember discussing 7 years ago, was an amendment to the Municipal Act, and doing away with joint and several, but only in respect to municipal highway claims. That's a proposal that might get some traction, because it's not changing the entire system of tort law in Ontario, right? But it singles out a sector of our society, the municipal governments, and it would give them relief in claims where they're getting sued every time somebody has an accident on a road, because they'd be stupid not to. If I were a plaintiff lawyer and I had a client who got hit or even drove their car off the road in the winter and was injured, you bet I'd tell them to sue a municipality. Why not? There's very little downside, and they can only go up from where they are. So that having been said, that's another proposal that may need to be discussed, and would obviously have a significant effect on the lawsuits that I deal with and defend in my day-to-day practice in Murray, I'm sure as well. It's pretty much all we do, right, is fighting these cases that get brought because our clients have lots of money, and they're the ones responsible for the road. So those are the alternatives that have been discussed that I'm aware of previously, and I imagine soon again. So this is now, I'm turning now to the questions that have been sent. So there was an email sent to heads of council around the province, and this is what they're looking for. So they've asked you to tell them about the nature of your insurance coverage. Question one's pretty straightforward. The answer is yes, you all purchase liability insurance. They're interested to know who you're insured with. They want to know if you use a broker and which one. And do you self-insure against some or all liability risks? And they want to know about your program of self-insurance, your retention if you have an SIR type situation. And most municipalities do have, especially the big ones, a significant self-insured retention that they deal with without having to go to an insurer. Premiums, they want to know what your premiums have been, percentage increases and absolute dollars over time. Now, I don't see that they've asked for a time frame, but obviously they want a historical snapshot, and that's pretty straightforward. They want to compare your other insurance premiums to your liability insurance. They want your property, your auto, your flood, and other stuff. They want to know, because they're trying to see if there is any noticeable trend of liability insurance premiums in being disproportionate or going up in a way that's unusual compared to the other lines. They want to know the typical ratio of premiums to claims payouts. They want to know what triggers premium increases. You know, is it because of the number of claims that you've been hit with in a period of time? And I think insurance companies or the insurers who are canvassed are going to have to step forward and explain this to the government, because it may not always be clear what's driving your premium increases, right? And the government points out that secondary literature speaks of insurance cycles or market tightening periodically. Do you have any views on this topic? Can't really comment on that myself, but you know, I certainly hear about markets hardening and it being tough, and that the insurance, municipal insurance business keeps getting more difficult, not better over time. Deductibles, they want to know what your deductible is. They want to know what the trigger for payment is, and any changes over time. In other words, have you been raising your deductible as a way to lower or maintain a lower insurance premium? They want to compare changes to your other business lines over time. So once again, comparing your liability deductible to your others. They want to know what's driving that. They want to know about your litigation costs, how much you're spending. Does joint and several liability impact your litigation costs, and any changes you've noticed over time? Are your cases any more expensive than other types of claims? And have you taken any steps to reduce your defense costs? So the cost of defending lawsuits, they're very interested in understanding that. So they're looking to you to help them with that. Types of claims. They're looking for data regarding types of claims, including auto, building inspections, other types of personal injuries. So they want to know the volume and the cost. They want to see what you're getting sued for and how often. And I've highlighted the next one, the number/portion of cases that involve two or more defendants and thus raise joint and several liability issues. So they're very interested in you telling them where you're getting named with multiple defendants as opposed to you're just the only defendant. And if you're seeing any changes over time in the types of lawsuits you're getting dragged into. Settlement of claims. They want to know about your joint and several liability cases, and ideally the specific cases where you've settled for amounts that are disproportionate to your fault. And you know, if you can give the government some clear-cut examples of payouts or settlements, cases that you just didn't take your shot at trial at because of the absolute distrust in the system, in the sense that you know, as I pointed out, judges telling you, hey, we're going to find a way to get this plaintiff paid, and you're the one with all the money, so buckle up, get your checkbook out. Those types of cases, if you can point to any, I think that would make a significant aggregate effect if 3/4 of the respondents can all point to 2 or 3 really big cases in the last 5 to 10 years that they've paid out millions of dollars, or potentially millions of dollars on, mainly because, not because you didn't think you had a shot at winning, but because the alternative was too risky to go to court. Then I think that'll have a huge effect. So that's one of the more important pieces of data I think you got to give them. Your non-joint and several liability cases, they want to know where you've paid amounts viewed as disproportionate to your level of fault. So in past, some stakeholders have identified single vehicle collisions involving impaired drivers as an example of that. Once again, I think that points to, again, the other issue that drives this, which is a judiciary or legal system that seems bent on making municipalities the de facto insurer of the people that are wandering around within their boundaries and having accidents or injuries. The adjudication of claims, they're looking for data regarding your joint and several liability cases that you've been involved in, and ideally specific examples in cases where you've been required to pay amounts disproportionate to your degree of fault as determined by the court. Now that's a toughie because that's talking about a trial judgment. The only time a judge is going to determine your degree of fault is because you've had a trial and you've taken that gamble. For those rare occasions where you've been bold enough to do it and maybe lost, I guess that's what they're looking for here. And they're looking for data about non-joint and several liability cases where you've been found liable and required to pay a lot of money disproportionate to what you felt your level of fault was. So again, the single vehicle impaired drivers. Claim costs. They want to know the cost of individual claims relating to injuries in automobile accidents, as an example, and if so, why? So they want to know if the costs are going up, and I imagine that's everything: your adjusting fees, your investigation, not just your legal costs, but all of your costs. And so the government here, as I've underlined, notes that in 2016 they reduced the cap for no fault for catastrophic payments from $2 million down to $1 million. This question's hilarious. Did that have any impact on municipal costs? Are you kidding me? Yeah. There's $1 million that these accident victims, for their future care costs, if they're CAT, that I don't have as a credit against what I'm going to be exposed to. In the tort claim, it goes straight off of the SOBs right into the tort claim. Same with the no crash, no cash system, right? For transit riders, the bus cases. Every penny they can't get out of the SOBs because of no crash, no cash goes into the lawsuit because the driver had to hit the brakes or somebody swerved and there's no collision, but there's a passenger on the bus hurt. And that's directly related to that. And so the government says, what savings are expected from the government's plan to increase the cap back to $2 million? Would a further increase to no-fault benefits result in savings to municipalities? And that's an interesting question. On its surface, I would argue, sure, absolutely. You put that extra $1 million back, and then in the worst type of lawsuits where my client's being sued for mainly the future care costs, if they're in a wheelchair and need 24-hour attendant care, that extra $1 million is well, it's about 12 months or less of future care that my client doesn't pay. When you look at the hard numbers, that's about it. The other things that they're asking for are settlements ever for a sum less than or equal to the deductible?
Yeah, still on the old slide.
Yep. Oh, I'm sorry. Yeah, claim costs. And then they want to know, how does joint and several liability positively impact catastrophically injured plaintiffs? How would associated costs be distributed if JSL is abolished? Well, yeah, of course it benefits them. The joint and several liability is unfair, but it's 100% in favor of the catastrophically injured plaintiffs. And how would those costs be distributed if it was abolished? It'd probably go on OHIP. I don't see what other answer there is. Where would it go? There's no claim compensation fund that the government sets up for tort victims who can't collect from all the defendants. What, if any, impact have road maintenance standards had on claims against municipalities? That's an interesting question as well. I venture to guess that it's not easy to answer. from my side of the fence as a municipal defense lawyer and practitioner, I think it's had a great effect. And the effect is plaintiffs are less likely to sue in the first place if they know that there's a minimum standards defense, a regulatory defense. They also certainly have a rough time when we trot out those maintenance standards as part of our defense. And I've had many cases that have either been dropped, pothole type claims or other type of road claims where I can point to the standards. My thought is absolutely. Apologies, this screen keeps shutting off, so I keep moving my mouse around to make sure we don't go dead. We're almost done. And then what types of everyday activities have been impacted by insurance costs and other liability risks? To what extent is joint and several liability a factor in these situations? Well, as I mentioned, if you have facilities that you've shut down or don't operate because you're worried about being exposed to a 1% type case or just litigation in general, I think that's an important thing. So thank you for listening to my rather lengthy academic discussion of joint and several liability. I'll take off my professor's hat now and put on my listening hat. And I invite those on the call to type in some questions for Scott or some comments. Perhaps we could start with what people think about the possible alternatives should be or could be, and what they're hearing out there in the world, or just throw some questions in. We'll stay on the line here for a minute.
Sure. So Charles, I'll put this to both of you. In terms of the proposals, the alternatives that you've identified for managing risk at the local level,
yeah.
In your experience or in your estimation, is there anything, if we suddenly land in a space where liability is being apportioned differently,
yes,
is there anything stopping the courts from simply readjusting their calculations to have municipalities backfill?
No, there isn't. Judges often, in my experience, decide a case based on what they want to see happen, and then they'll reverse engineer the decision based on what they either know or they guess is going to be the necessary percentage to make sure the plaintiff gets all their money. That being said, we could if there's some rationality to it at all, you can appeal, and trial judges, even the most unfair ones, on occasion get overturned on appeal, especially if they make a ridiculously high percentage finding of liability in a very questionable case. But that's, if you're taking cases up to the Court of Appeal as your only means of leveling the playing field, you've lost, because you're paying tons of legal fees, and it's hard to win on appeal because it's a mixed question of fact and law, right? And that's a nice way of saying it's whatever the hell the judge decides. You've got to prove they just totally blew it or were completely crooked to have any shot at the Court of Appeal, as Marie and I have found out the hard way.
We have managed to kick around some judicial findings at trial, though. As Charles says, if they get ridiculous enough, the Court of Appeal feels an obligation to do something about it, and that's good.
Yeah.
In a similar vein, I think that a lot of the attention that focuses on this has been in terms of roadway or accidents, catastrophic accidents taking place in the roadways. Our members are in the process of crafting responses to this questionnaire that you just ran through. What are some of the other areas of responsibility that municipalities have that, again, in your experience, you've seen joint and several liability applied disadvantageously to the municipal sector?
Sure. Well, outside of road maintenance cases, highway disrepair cases, building code. The building code liability cases are some of the worst and most unfair, because you can have some fly-by-night builder who threw up some, very shoddy house or building, who's got no money, no insurance, probably never really existed as anything but a shell corporation anyway. And then you got a plaintiff who opens a wall up and finds something wrong and starts suing. Oh, the building inspection was negligent, right? And you've got to go and try and find your file somewhere in a dusty warehouse 15 years later and the building inspector who did the inspection retired 20 years early. It's a nightmare. The building code ones are nasty, and they lurk out there. The other one that I see potentially, although it's not necessarily joint and several liability, is obviously sewer backups or flood claims. Those flood claims are getting worse and worse with global warming, all the storms we have. But really, that's primarily it. There's the odd occupier's liability case that crops up, and you sometimes have joint and several issues that arise there. But it's going to be the building code cases and the road maintenance cases.
Police cases, if you have a police force.
Yeah, that's true.
Are a big one.
What about public health? We recently became aware of a class action lawsuit that targeted a tattoo parlor where public health was deemed to have been negligent in terms of their inspection of the facilities.
I would equate that. That's akin to a building code case, a licensing negligence case. But where there's an inspection, that's really the kicker, right? Any type of municipal inspection, if it's done negligently, you're going to face joint and several exposure. It's just the nature of the beast for sure.
What about Drainage Act? Has that ever come up?
Well, in the context of certain flood loss claims, absolutely. Yeah. With the global warming and the environment change we're having, there's a lot of municipalities that are having, well, look at Lake Ontario, 6 feet higher than normal, right? Cottage country wiped out once again this spring. The Drainage Act is an interesting and archaic piece of law. It goes back almost well over a century. And not many people, even me, pretend to understand it, but the times I've had to deal with it, especially we have neighboring properties and water flowing, a nuisance claim from one land across municipal land to someone else, and you're the monkey in the middle, so to speak. You're caught. Those are tough. Environmental loss claims.
Well, it doesn't even have to cross municipal land. If one, especially down in southwestern Ontario, where Drainage Act is used quite extensively, if one resident impacts another, if the drainage inspector, who is a municipal employee, is deemed to be negligent, then the municipality can be pulled into essentially feuds between adjacent properties.
Yeah.
But Joe, those cases don't generate the same kind of pity that a severe personal injury to a teenager. So you're not quite as much at risk when it comes to something like that. It's a couple of landowners.
Yeah.
So another question that comes up all the time in talking to our members is the conflation between what we'll call true joint and several liability cases and liability chill more broadly.
Right.
I'm wondering if you can elaborate on that and give us the thumbshell version of how the liability chill differs from what's being entertained by the province.
Sure. Well, liability chill can take many different forms. Obviously, the risk of being held liable, not just jointly and severally, but liable at all, is something that many of my clients tell me about as being a concern. And I would say in the last 5 years, public facilities like parks and tobogganing is a big concern. You get a 12 or 13-year-old kid who hits their head on the tree at the bottom of the tobogganing hill, you've got a big claim on your hands. And the courts have shown in numerous cases that they're not going to use the provisions of the Occupiers Liability Act or Valenti defense of assumption of risk to give you any breaks. And, the case with the mountain bike on the teeter-totter, right? That type of thing, that's gone. They've got to shut those types of facilities down. If you're operating one of those and you don't have $20 million of insurance on it, you're crazy. So
the chill flops over to other target defendants as well, like school boards. They're not running ski trips anymore because two kids run into each other and there's a big claim. It's all fueled by the willingness of our judiciary to whack the deep pocket defendant, often using the 1% rule.
Yes.
We have a question posted here asking if the province itself is exempt from joint and several liability.
Well, apparently the province is exempt now from all liability because they just changed the proceedings against the Crown Act. And it's being, I have a case now where I had to sue the province of Ontario as a third party in litigation. And they've just trotted out the new retroactive provisions of that new legislation and suggested that essentially everything now is a policy decision immune from suit. So, or what they're calling a regulatory decision. We're moving into some very interesting times, but it's an interesting question because the province is so willing and ready to protect itself from litigation. And I understand there's several class action lawsuits currently underway and have been for several years that are going to get wiped out by this new Crown Liability and Proceedings Act. And it literally wiped out. It's going to save the province millions and millions, potentially hundreds of millions of dollars. And the somewhat cynical side of me as a lawyer suggests that perhaps that was some of the big motivation for this new legislation, which was sold, if you read your media reports about it, as just codifying the common law, your policy immunity, which municipalities enjoy under Section 450 of the Act, in theory. So, yeah, it's interesting, very interesting.
But as part of that same topic, I wanted to put up on the table for in the background of any questions and discussions, the thing that has to keep getting hammered by the municipal world is the fact that this joint and several liability rule has an inordinately gigantic impact on municipalities, and it's come to be unfair in that way. It also applies to other deep pocket defendants, but in the particular case of our clients, and there's so many of all of you listening across the province that are being impacted by this thing in an unfair way, that's what we're screaming about. We're not saying that this is an essentially unfair rule of law, because it's hard to get away with that. But what we're saying is this unfair rule of law has an inordinately huge impact on our section of society, which includes everybody who lives in a municipality and pays taxes. I think it's really important to keep that.
And that's by nature of the fact that municipalities own most of the public realm where people lead their lives.
Yeah, we're a big target. We're a big target, And two other thoughts I wanted to toss out while I think of it. We have to remember that the classic 1% case here is, as Charles touched on, a couple of young people in a car goes off a curve at a high rate of speed. The driver's clearly at fault. He's got minimum insurance limits. The passenger, who was wearing a seatbelt and not really doing anything wrong, has a $20 million catastrophic injury. Plaintiff's lawyer says, holy cow, there's not enough insurance. What do? We go to our battery of engineers who then get turned loose on the curve and say, well, it was too sharp. The sign warning of it should have been different. There should have been chevrons. There should have been edge lines. In short, they throw out a basket of that any judge can reach into to pull out 1% of responsibility. And what happens if there's $500,000 insurance on the car and the damages are 20, and the municipality is crazy enough to try the case and lose? They end up paying $19.5 million when they shouldn't be paying anything. And the problem is nothing that we've discussed here this morning will take that away. And because all the alternatives that have been discussed contemplate some finding of contributory negligence on the plaintiff, but it's the really innocent ones that I must say over my career, I have paid out tens of millions of dollars that never should have been paid, but purely because of the prospect that if we litigate the thing, we're going to get hammered. The final thought I want to throw out is, let's not forget that you don't have to lose a case for it to cost, in a meaningful way, the municipality. I'm working on one right now where two cars were in a head-on collision. One person is driving along. She leans down to adjust her radio, looks up. She's crossed the center line. There's a car coming the other direction with a young family in it. The father's driving. He swerves across the center line trying to avoid her. She turns back into her lane, and they head on in the middle of the road. The mother of the family's in the back seat of the car. She's catastrophically injured. Her damages are probably $18 to $20 million. There's $1 million on the car that crossed the center line in the first place. They've sued the father because they say he acted improperly in trying to, avoid the accident. And maybe there's $1 million on that car. Big deal. It's $2 million. Plus they get no fault benefits. And of course, the plaintiff has named any municipality in sight. My client is one of them. There is absolutely no liability. If this case went all the way to trial, I would win. But it will cost us hundreds of thousands of dollars. Just the expert reports alone will be $30,000 probably, and the adjusting costs and my fees. And, all of that stuff adds up over a period of time, and it should be not forgotten about. It goes into the mix.
So another question that's been posed to us since you raised it. It seems mildly out of scope, but I think it's worth asking. Will the province be able to defend a higher court challenge of its self-claimed exemption to joint and several?
Well, of course, the province can legislate again. They make the law, so if one of their pieces of legislation gets struck down, they'll just introduce a new bill, and whatever the court found wrong with it, they'll try and tweak, and then it will get challenged again, and then maybe they'll tweak it again. My thought is this, I'll say it quite bluntly. I've already told the lawyer for the province on the case that I've sued the province as a co-defendant. I've told them that I think there's a charter challenge to this new legislation, that it may violate Section 7 of the charter. Because if you can't sue the province for any sort of negligence, that is shocking, and it goes against the idea that everyone should bear liability for their wrongdoing to a certain extent. So it's interesting. I find myself doing something on behalf of municipality against the province that I complain about, which is, oh, you're sucking me into a lawsuit. But the underlying facts of my case are pretty interesting. Anyway, I won't go into it. But the answer is, yeah, they can defend it, and if they lose, they'll just try again if they want. Depends who's sitting in Queen's Park.
So a question's been posed about the benefits of requiring a greater coverage for individual automotive or individual drivers in terms of their liability coverage.
Yeah.
You touched on it during your presentation, but I'm wondering if you can expand on what the impact would be of having every driver have $5 million coverage.
Well, in Murray's case, 2 cars, only $1 million on each car. If each car had 5, then you've got 10, and the municipality's facing a much smaller, not a $19 million potential payout on joint and several, but a much lower payout. So it would help a lot in just that one example. The problem is you've got fairly low third-party liability limits, on average, $1 million on a car, and SOBs have been cut in half for catastrophic. And the no crash, no cash system, which doesn't pay any SOBs to people if there's no collision involving vehicles. All of that goes into the lawsuit. Every penny they can't get out of the no-fault insurance scheme or the insurance for vehicles comes right to the tort claim, right to the lawsuit. So it makes a big, big difference. And everyone I've talked to about joint and several has told me that they think that that would make a big difference.
How do municipalities avoid creating a standard for every single part of road maintenance? Snow fences are referenced as a great example. There's not necessarily a standard for snow fences, but it's something that comes up in cases.
So snow fences, interesting.
I think that's used as the example. The primary concern is how you avoid creating all of these competing standards.
That's kind of an interesting question. I suppose the duty as one of the members on the last task force is trying to come up with very clear, as best we could, focused standards. Unfortunately, the maintenance standards don't cover everything, and the ones that we have landed on, we've done our best to streamline. I don't know what else I can say to that at the moment. We do our best to try and focus on the big claims. We did sidewalks. I think the biggest one now is the winter sidewalk standard. It'll be interesting to see how that standard, both for inspection and for maintenance, especially ice prevention on sidewalks, which is one of the bigger areas of litigation that's left now against municipalities, that still goes strong every winter, are those standards. So it'll be interesting to see how those play out now that we're into our second year.
Another question around the nature of settlements and whether or not there's a sense that settling is fair and an accurate reflection of the liability that has been assumed by the municipal sector.
Well, settlements definitely are driven by risk, and risk is driven by the 1% rule. So there's a straight line relationship in my mind as a lawyer to looking at the amount of money a municipality pays out annually in settlements and joint and several liability. It may not always be the case, because not every case is many times you're just being sued as the only defendant. Little Johnny slips and falls at a community center because the floor was wet. You can't blame that on joint and several, but it certainly is part of the mix. So I think obviously what the government has been asking in that list of questions is very focused. They're asking you to identify your joint and several claims, so where you're named as one of multiple defendants, and that's easy. You look at the statement of claim, you know if you're the only one or not, and then to try and go back and look at your history of settlements and what you paid on those claims and why. And I think the why in almost every joint and several case is going to have to be related to the increased risk. There are admittedly cases where you are one of multiple defendants and you're the one who screwed up and your co-defendants really didn't do anything wrong and you're legitimately the target and for good reason. And if you settle one of those, you can't blame that on joint and several, because you're paying what you ought to pay, because you're being honest with yourself and you're not trying to just use the legal system to move out of your obligation to make right what you did wrong.
Are either of you aware of any consideration that's been given to developing some sort of supplemental fund to address losses incurred during motor vehicle accidents?
Yeah, well, there already is a motor vehicle accident claims compensation fund. It has come up rarely in my litigation career, but before I became a full-time municipal defense lawyer, I did a lot of motor vehicle defense work for big insurance companies. How I got my start, and all I can say is it was the fund of last resort. They set it up so that it's very difficult to make a claim against. They use every excuse not to pay money out of it. So they act like an insurance company when it's supposed to be a fund for victims who can't get paid. And you end up having to sue them. You have to go and take them to the License Appeal Tribunal to get them to pay out sometimes. Conceptually, there already is a fund. It could be vastly improved if the answer, in conjunction with do away with joint and several entirely in Ontario, there's going to have to be a publicly funded program for victims to apply to and get paid, like workers' compensation, right? Same idea. That's going to be, and who's going to fund that? And whose tax money is going to go to that? Do municipalities pay into it? Do insurers pay into it? Does everybody in the province pay an extra $20 a year into the fund? Wildly unpopular.
We already did.
Well, yeah.
I thought part of my personal insurance premium
goes to the fund.
Goes to that fund, does it not?
Yeah, I'd like to know how much money they pay out every year and to who. I would maybe one of the pushback points here for our municipal friends that are still on the line, and I see almost 70 of you are still kind enough to listen in this far, so thank you all for that. Is to ask for that data from the government of Ontario. How much have you been paying out under the motor vehicle accident claims fund? And why not? Why not more? How much is in? How much are they holding in trust somewhere? You know, how big is that money, and what kind of interest is it generating? I'd love to know.
Gazing into your crystal ball, all orders of governments struggle to respond to emerging technology, and the one that is most ominously facing road authorities is autonomous vehicles. In your opinion, what's the impact that autonomous vehicles will have on future legal claims and some of the associated costs that municipalities bear?
It's difficult for me to be able to give a clear answer, but looking forward, if there's more accidents, let's say autonomous vehicles become the norm, and they're out there crashing, and somebody says, oh, you know, the computer misread the edge line. And it happened. There's actually, we're testing one of these vehicles, and there were some dots on the road, and it freaked the car out. You're going to get sued for those dots having been, right? It's not the computer's fault. It's because the municipalities put some lines or dots on its road by accident or on purpose.
Well, in that case, I think
you're going to get sued.
In that case, I think some brilliant IT kids did it as an experiment.
Oh, okay.
Put the paint on the road, and the car,
see if they could freak it out.
Car went out of control. And the other thing, the big thing about, I was just on a speaking tour a couple of months ago, and one of the other people involved was speaking about autonomous vehicles, and one of the things that came clear is it's going to be a long time before they are broadly driving in Canada. You know why? Because if there's snow on the road, they can't read the edges and they can't operate. So in Canada in winter, you don't have any of these cars.
We also were monitoring a situation in Boston where a rather aggressive flock of seagulls managed to totally gum up the technology. So
yeah.
I'm just looking through the other questions here.
And thank you everyone who's listening for these questions. They're really interesting questions, and it's experiences like this that are really fun for me and for Murray, I think, because we always get really good ideas that flow from this type of process.
By all means.
I agree with that. And one thought I wanted to toss out. I happen to know that some of our insurance friends are here, and we haven't touched on that, but it would be very, very helpful if the insurance companies could contribute some of their statistics. And I know there are issues about privacy, but I know some of them are attempting to help here. And I guess from the municipality standpoint, if they go back up the pipe to their insurer and say, look, we need help establishing the statistics and the data that are going to be required if we're going to have any success in doing anything with joint and several, then give us a hand. And thank you in advance.
Mm-hmm.
Question here asking if the Crown and Legal Proceedings Act mean that provincial highways and MTO cannot be sued. The municipality in question has a claim for $5 million plus with the town, MTO, driver, and our engineering firm being sued. In our opinion, MTO is a significant fault as the road is within the connecting link.
Well, if this new piece of legislation is what some say it is, and it has the effect of essentially rendering null and void the claim against the province, you're in a heap of trouble then. If they're the ones who would normally you'd be looking to, and you think they bear the lion's share of liability. The funny thing is that there's a provision in the new act that says, well, any claim that's caught by the new immunities that are legislated is deemed to be dismissed without cost effective July 1st, 2019. So this literally just a month ago came into force. So it's hot off the presses. So wonderful. The province will get out, but they can't come after you for their costs. But the problem now is going forward, any case where you're suing the province of Ontario, the legal fees that they're incurring on their end from July 1st forward they can come after you for. So they're going to send their threatening letter, or their lawyer will call and say, hey, section 11 or 12, whatever it is of the new act, we say if you read it blocks your claim against us. So here's your consent dismissal order, sign it. And if we don't hear from you in 2 weeks, then we're going to come after you for all of the costs going forward if you carry on against us. And they may bring summary judgment motions. The pushback for you on that one is you hire Paterson, MacDougall, and we'll launch a charter challenge against the new legislation. And we'll keep the province hooked into the action for you. So yeah, it's going to be, as I said, this new act is worthy of its own webinar. I think at some point I'm going to have to put on a CLE just for our many municipal clients to wrap our heads around the scope. And it's so new, it's going to be really interesting to see what happens. Stay tuned. There's more to come in the media as well, I'm sure.
Building on what Murray was just speaking to, do municipalities stand to benefit by telling their insurers that they're willing to waive their privacy in terms of data collection or stats outcomes?
Well, sure. I mean, obviously, to give them the full comprehensive picture, you are going to be disclosing certain confidential information. I would, and this is something that every municipal participant on this call or who provides information to the province, it's unclear to me what the province intends to do with this data. Any government collected information typically is public information. So anything you send into the government of Ontario in response to this call for comments is going into someone's database, and if I were a clever person, I would file a Freedom of Information request and get it. And find out all kinds of stuff. And so, one of the things that I would encourage everybody on this call, not to discourage you from providing the information, but to perhaps reach out to the province or to whom you're communicating through AMO and ask them to make that inquiry, because I can't imagine that the people who are asking you for this information on the government side wouldn't be willing to consider maintaining certain level of confidentiality on some of this data that they're asking for as a means to encourage you to make that full and frank disclosure to them. But it's an interesting point that's been raised and well worth thinking very carefully about. I have not been giving legal advice to any client yet on how to respond to these questions, but hypothetically, if I was your lawyer, and you were going to send this kind of information to anybody, I'd want to know where it's going, who's going to have access to it, and those important questions. At this point, you have to assume whatever you send them, it's going to be publicly available. So if it's not something you want to put in a council report or have open for public, at this point, you should exercise caution, pending further comment from the government.
One thought I have is, who cares? If the municipality gives out information that sets out the effect that joint and several has had on them, as long as no individual plaintiffs are named, who cares? There's the privacy to the municipality. I just don't see that as being harmful. I know from the standpoint of the insurers who are being asked for information, that's a concern of theirs. They don't want information about individual plaintiffs. They don't want information about their premiums to get out and be in front of the whole market. So
yeah, they don't want their competitors to see.
Exactly. There are privacy issues there, but I don't think there's any privacy issue in a municipality putting forward the kind of data that we're seeking here.
So, building on that, how would you recommend municipalities quantify the measures and the steps they've taken to respond to joint and several liability, or the 1% rule, and in particular, looking at costs that they may have, preventative costs they may have incurred, or other considerations over the last decade? What is the best way for them to package this information in your mind?
Sure. The most important information, in my humble opinion, they can provide is give the province examples. Give them an example of a a joint and several or road case where there was a defendant driver and you were brought in, because you're the road authority and you've got a catastrophically or maybe even not a catastrophically injured victim, and there was a trial or a settlement, and how much you paid and the why, and say, look, here's a list of cases, year, payout, joint and several, and packaging that with, had we not been exposed to joint and several, we believe we would have paid X. The delta between what you paid and what you thought you should have, right? And be honest about that. I think honesty is obviously very important here, because we don't want to look like we're being greedy or anything less than fully transparent with our partners at the provincial level on this one. So I think that's very important. The other thing is, are there facilities or activities that the municipality just doesn't do anymore? Not only because of joint and several, but because of liability generally, because we are talking about a legal system. We're talking about a legal system that's plaintiff friendly, and deep pocket defendants are the targets across the board, not just jointly and severally. But it's really the key examples are the number one, and then of course, to the extent you're able to just give them the numbers on your insurance premiums, I mean, those are straightforward, data points.
And let's not forget, you talked about self-insured retentions.
Mm-hmm.
Municipalities have been forced to accept larger and larger SIRs in order to keep their premiums reduced. But the consequence of that is that there's a very high proportion of the claims against them that are dealt with within the SIR, the adjusting costs, expert fees, and so on. And sometimes the retention is high enough that even a settlement is covered by that, and it doesn't even touch the insurer. So there's a lot of data and information that is in the hands of the municipality, and they should get somebody working on assembling the information that's necessary.
How do municipalities overcome confidentiality clauses that may have been included in settlements?
Right. So the simple way to do that is you got to look to the confidentiality agreement itself to see if you have any ability to disclose any of it. Obviously, is it a one-way confidentiality clause? My typical confidentiality clause is only executed by the plaintiff. So the plaintiff says to me, when I settle, they will not. My client can do whatever the heck they want, but the plaintiff is not going to tell their neighbors about all the money they just got, so that their neighbors start suing us too. They don't run to the media, and their lawyers don't put it on their website. Hey, hit the city for X, hundreds of thousands, rah-rah thing. Those confidentiality clauses are a contract, but they're a contract that only favors my municipal client. And there's nothing in that contract typically that prevents my client from doing what they want. Now, mind you, once you start talking about the claim, and of course you can do it on a no-names basis if you don't want to name the plaintiff, and that's probably fine across the board here as well. But once you waive that confidentiality, then don't get upset if a plaintiff were to talk about it. But again, if you don't identify them in the data by name, then you're probably not going to have an issue. But again, in-house legal counsel, municipal lawyer, or someone like me, if you want to have me give you a legal opinion, you know where to find me. Send me the confidentiality agreement. I'd look at it and decide whether it's something that presents any issue. But generally, shouldn't be a problem.
Yeah, and I think the main thing you're looking for is the number. And if you're not tying that number to a particular plaintiff or a particular case,
yeah,
it goes into the pot to show what's been paid out.
Yeah, you're trying to create silos. Slip and fall claims X, or joint and several mainly road claims. Bang.
Yeah.
Okay, we have one final question in the queue here, and given that we're getting close to the end of our allotted time, I think it's probably a good point to wrap up on. There's strength in numbers. No sooner do I say that, and another question appears. Let's go to the one that just came out first. It's more a comment than anything. It was It was the relative the influence of municipal size on this consideration, and saying that small municipalities tend not to be in court as often, and that by nature of having fewer constituents, people still figure out who the parties involved are.
Ah, right. Good point. Small town, everyone knows everybody. Interesting comment. I suppose it's not as simple then in some respects as just taking a person's name off. But that having been said, again, if you've settled and there's no confidentiality clause, then you're not breaching any contract. You're not voiding a settlement, and you're free to discuss it. You know, you gotta look at it. At the end of the day, those citizens of your municipality are probably just as interested in having their taxes not go up as any other citizen. So if joint and several changes and you don't have to pay as much for premiums and pay out large deductibles that come straight out of the that same tax base, I don't see a problem.
I figure go ahead and take the chance. Give out the information about the amount, because it's the small municipalities who are disproportionately affected by this. It only takes one catastrophic injury to happen on your little county road to drag you into a $20 million lawsuit. So it really behooves you to do whatever you can to reduce your exposure.
All right, and then the last question, as I said, strength in numbers, 444 municipalities. You've identified a number of recommendations or possible alternatives, as you've titled them.
Yeah.
Are there one or two that you would put your name beside as being worthy of pursuit and that municipalities should employ?
Sure.
And why?
So in terms of the possible alternatives, you know, from a purely practical standpoint, at this point, I think if there's going to be a chance, it's going to be the Saskatchewan multiplier hybrid model that was championed by AMO the last time. I think that is as much as we could possibly hope for. Now, I say that, and I know some out there are going to say, "What the heck are you talking about? Why aren't we just getting rid of joint and several?" Right? If the government of Ontario is willing to entertain that, then let's go for it and champion that. But there'll have to be a victims compensation fund, a tort victims compensation fund, set up to be the safety net, because I'm telling you, there's not going to be a wholesale doing away with joint and several liability in this province without something like that. If the government's prepared to discuss that, then that would be my first pick. If the government's not prepared to discuss that, then it's going to be option B, which is baby steps, get a Saskatchewan system in place, get some relief, combined with the multiplier that caps the max. I think if you could get that, that would be a huge win, because this is just the first step. We have no tort reform in Ontario. Nothing. We've got the harsh, pure joint and several with no relief in any situation.
And by the way, fully half of the states south of the border have either done away with it or modified it significantly.
Yeah, 38.
We haven't. One final, just before you close off the thing, Scott, Charles and I have discussed these alternatives to the point where we're blue in the face. I was kind of hoping we might get some input from the participants today on what they think about as a possible alternative among the ones that we've tossed out here.
So by all means, feel free to share that. I don't think we have the time to do that today, unfortunately, Mark.
But they can still send in their thoughts.
Absolutely, but we are more than willing to act as a conduit. There's a late question here, and I think it's probably even better to wrap up on this one. What's your confidence in the process this time? I think this is a well-worn path, and municipalities may feel somewhat pessimistic that meaningful reform is going to happen.
Can I deal with that? Because I first dealt with an attack on joint and several liability back in the 1980s. I had a case called, well, I better not mention the municipality, but there were two kids who were trespassing on some future parkland that was put in the name of the municipality. they were on trail bikes and they collided with each other, and one of them was catastrophically injured. Judge at the trial, because there was absolutely no liability, shouldn't have been any liability. The judge at the trial bent over backwards and awarded, at the time, the largest personal injury judgment in Canadian history against me and my client. It was only $7 million. When you think about it, it's triple that now. But it created such a stir that I know some municipalities whose insurers canceled their coverage mid-policy. And there was a huge crisis. Monty Quinter was the minister at the time, and he set up an insurance crisis committee, and he asked me to address it. And I went and spoke to them, and I discussed all the stuff that we've talked about today. And they made a recommendation of the Law Reform Commission that joint and several be done away with, because it was such an outrageous harm that was being done to the municipalities. Never heard from it again. And then there have been a couple of subsequent efforts, one of them by AMO last, and so on. And we all know the results, nothing. This time around, we got Doug Ford. Now, I know he's got some other issues, but when I first read the first missive that came out from the government saying, hey, we're going to look at this, it struck me as an old hand and trying to deal with it, and unsuccessfully. But this may be our best opportunity, because we know that he doesn't seem to be reluctant to reach out and make changes. And so I kind of felt that this was our best shot in a long, long time, provided he doesn't get totally distracted by all of the other stuff that's going on in his government. So we may not get another chance like this for a heck of a long time, certainly not in my future career. So that's why I'm saying go for it.
Yeah, the success this time around will depend on you. All the people on this call listening, all the people who were on the call earlier, and all 300 other municipalities out there who may not have had the ability to dial in, it's up to you guys. You got to chew their ear off with the responses that you send into these questions. You got to hit them with as much as you can give them, and you got to make it clear that you want something done, or there's going to be hell to pay, and that'll be the determining factor. It's always interesting, and as you say, strength in numbers. But every one of you has a key role to play in this. So that's my final comment.
Okay. Well,
just to wrap up, Scott, I just want to thank Murray and Charles for taking the time today to put on this webinar. It has been recorded, and it will be posted on the OGRA website for anyone who wants to access it later. Thanks, Murray and Charles, for your input on this, and let's hope that we can get some results this time around.
all right.
Thank you, guys.
Awesome.
Welcome, Joe.
Good day, everyone. Thank you.